Right, I am. Good afternoon. Good afternoon, Senate Finance and guest. It is Monday, March 27th, 2023. We have one bill before us for consideration, and I've been reminded by the chair and probably the vice chair of executive noms that some of us will need to leave at time specific. So with that, we're going to ask David to walk us through Senate Bill 516. And as we start, let me just thank you all committee, and I'll do this time and time again. There has been a lot of work from each of the members on this committee and many of our colleagues in the Senate, many stakeholders that have provided input. Some have been working in partnership with our colleagues in the House. Our staff has put in a lot of time and a lot of hours hearing from each of us about little modifications, some little, some big, that we would like to see to this bill. Also want to thank those that, as I said, worked over the interim and brought the bill before us. As you all know, we have a date by which we're supposed to stand up this program. And so we have before us Senate Bill 516 with amendments. Many of them have come from you all. So I'll ask David to walk through what we have before us today. Thanks, David.
As the chair says, you have two things in front of you. You have a 100+ page reprint, and you also have a 50-page amendment. Normally, we try to run through the reprint, but I think in this case, it might be more efficient to just go through the amendments. If you can follow along, and I'll describe each amendment that you have in front of you. These are amendments offered by the chair. And first off, there's a lot of amendments in here that came over on the House bill. So many of the House amendments were technical and made some adjustments regarding the language in the bill regarding banks and this and that to just make sure this whole thing's going to work if it gets enacted in a couple months. So I'd say at least 80% of the amendments in here are from the House with no changes. In some cases, if there's changes or the House amendment's not in there anymore, I'll try to point that out as we go through here. So on the surface, this is an emergency bill that renames the Alcohol and Tobacco Commission as the Alcohol, Tobacco, and Cannabis Commission. It also at some point renames the article from the Alcoholic Beverages article to the Alcohol, Cannabis, and Tobacco, or Alcohol, Tobacco, Alcohol, and Cannabis article. The bill establishes a licensing framework for the regulated sale of cannabis in the state and establishes sales and use tax applicable to the sale of adult use cannabis, establishes the Office of Social Equity within the Alcohol and Tobacco Commission, establishes an advisory board, and includes various provisions to encourage participation by social equity applicants. Also, in the amendments in front of you, and the bill was introduced, and as amended by the House, it created a division of cannabis enforcement. This bill would change that to the Maryland Cannabis Administration. So wherever you saw a division in the bill in the reprint, it's going to be changed to division, and it establishes the Maryland Cannabis Administration as an independent unit in state government. So that's one of the amendments, actually near the end of your amendment packet, but that will make conforming changes throughout the bill eventually. The first amendment updates the purpose, paragraph, and bill title. Amendment 2 is largely unchanged from the House. It makes numerous technical changes to clarify definitions and agency responsibilities, moves the definition of cannabis from one part of the code to another, and defines political subdivision. It specifies, and these are amendments from the Senate. It specifies requirements for 2 members of the Alcohol and Tobacco and Cannabis Commission. That's on page 5 if you want to see what those requirements are. It alters the role of the Office of Social Equity regarding the Business Assistance Fund. This was amendments offered from the Department of Commerce to allow them to be the administrators of the fund and rely on the advice of the Office of Social Equity regarding making loans and grants from that fund. It clarifies reporting requirements, and it standardizes language and into transfer positions.
Can I ask you a question? Questions as we do this, or are we?
It's up to you.
Circle all the way back again?
It might be better to have.
Senator Kramer has a question.
Thank you. On that.
Do you want to
very
pull your
last-
microphone up, Senator?
Oh, thank you. Just real fast on that last point, because I'm trying to keep up with you. It has reporting requirements. We discussed going from every other year to annual. Is that at this point that change happened? Or is it elsewhere?
It's not in this amendment, but that is in a subsequent amendment.
Okay, that's all I needed. Thank you.
Okay, amendment number 3. It places the Office of Social Equity over the Social Equity Partnership Grant Program. The bill establishes this grant program. I'll give you a little background on it. It's designed to help existing cannabis licensees mentor social equity licensees to get started in the business. There's money they can get for this purpose, and it allows for this partnership to occur. However, in the bills introduced, it was unclear whether the social equity licensees who received licenses as a result of HB2 were authorized to participate in this grant program. So on Amendment 3, it defines social equity licensee to participate for the purposes of participating in the Social Equity Partnership Grant Program. You can see that definition on page 16. It adds, at the request of the Attorney General, reporting requirements relating to continued use of social equity requirements through the whole awarding of the license process established in the bill. It adds a technical amendment from the treasurer regarding the use of state credit unions. This language is no longer going to be as it appears in the amendment. It's instead of what it did, that's going to be gone. And instead there'll be an and to an, and just simply an and change to an or to allow the treasurer to use state chartered banks. That's on page 84 in the back of the reprint. It's in amendment number 3, so you can see it in amendment number 3. Yeah. Okay, some of these amendments are pretty long.
Yeah, exactly. That's why I was asking what page.
And I would think it's on the,
Senator Kramer has a question.
It's gonna be a challenge.
it's going to be a challenge.
Yeah, but seriously, we weren't, I was thought we were working on the amendment package.
Only, honestly, I'm not, like getting crazy over raising your hand. People are watching or listening via stream. So I just want your question
Yeah.
on the. Yeah.
It's on page 13 of the amendments. It's new language is added and it's going to be altered completely. Credit unions will all be taken out.
Okay.
And at the request of the treasurer, there is a clarifying change that if you go to page 14 of the amendment, where you see the and that is bracketed out, that's going to be replaced eventually by an or. So it'll be financial institution means one of the 4, not all of the 4.
Microphone. Thank you. All right, but as far as the state government being able to bank with credit unions, that language is out.
It's out, yes.
Okay.
There's no mention of, and anywhere where you see credit union in that part of this amendment is going to be taken out.
Is out. Got it. Thank you.
Okay, so we were on amendment number 3. Okay, and it clarifies the role of state testing labs and clarifies banking language. These were amendments that were carried over from the House to allow banks to take deposits and provide capital to cannabis licensees in the state. Next is amendment 4, which begins on page 14 of the amendments. There are no real changes here from the Senate from what the House did. It specifies that a cannabis registrant is not a delivery service. It strikes the authorization for a dispensary to repackage, reprocess cannabis. It specifies that a grower can't distribute cannabis or cannabis products. And it prohibits a dispensary from repackaging and reprocessing cannabis, transforming cannabis into another product, and rolling cannabis for smoking. So that's the amendments that are in Amendment 14. If you want to see what they look like in the reprint, they're on page 68 for the prohibition.
We'll go Senator Hayes, Senator Beidle, Senator Mounts.
David, you said that the repackaging was a part of the House bill and we're maintaining that in the Senate bill.
Yes.
And you know why it's being struck out?
My understanding was that there are issues with repackaging and it could create product diversion. And that according to the commission, they are investigating several instances where product comes in and then what goes out doesn't match what comes in. So it's an issue of product diversion. Also,
So the commission requested this language?
I don't think the commission, it came from the House.
Gotcha. Okay.
And my understanding is also 15 states already prohibit this practice.
Gotcha.
Senator Beidle.
Thank you, Madam Chair. So I guess what we heard in testimony was very often the cannabis comes in like a 10-pound package. And so the local dispensary will break it down and sell it in what would be typical size delivery. So how does that happen? I mean, if we can't repackage, people aren't going to come in, I hope not come in and buy 10 pounds of marijuana. That's a lot of cannabis.
So can we put a hold on this one and come back to it? Because I don't know, let me hear the other questions if there's going to be a way to address that. Okay, thank you. We'll go to, I have Senator Mounts, then Senator Klossmeyer.
Thank you, Chair. Just quickly, so if there is an entity that is currently repackaging, this as drafted becomes law, would they be grandfathered or would they just be they would just be prohibited from doing the act?
They would be
from
prohibited
performing?
under the bill. Cause not, not all, my understanding is not all dispensaries repackage. So it would be an outright prohibition on that going forward.
But even if they paid the conversion fee, they would still be prohibited? So
Yes.
Thank you, Senator.
Thank you, Madam Chair. I just want to follow up with what Senator Beidle said. I mean, you can't buy that much. And and I don't know how it all works, so I appreciate you saying that we'll come back to this and maybe it can be explained a little bit better to me. Okay?
Thank you, Senator Reedy.
Thank you. Definitely want to hear explanation later about that specific issue. One other sort of subcategory would be, I spoke to a couple different people involved in the processing. They talked about how they have machines that do the rolling of it too. I mean, I think they are at dispensaries as far as I know. They may be the producers. I'm not sure, but I'm just, this doesn't say the processors can still do what they need to do.
It doesn't affect the processors. It only affects the dispensaries.
Okay. That's good. The dispensaries is important too, but I was curious about the processors. And then just as a throw in, why can't we just say that the commission will adopt regulations governing this? Because it seems like something that ought to be more of a commission regulation to me than putting it specifically in law. I definitely know what we're trying to stop. We don't want repackaging into stuff that's not appropriate or is marketed to kids or whatever. Totally agree. Anyway, we'll come back to it. You said we come back to, but to me, it seems like it'd be better for like a regulatory scheme.
No, definitely hear the concerns, and I think you hear what the whole tracking and seed to sale and repackaging, what does that do in the tracking process? I think is a part of the reason why the House may have adopted that language. As you all know, they track the products from seed to sale, and if it's put in a different package, we don't know what lot it came from or what batch it came from. So I think that's a part of the concern. Let me go to Senator Lamb.
Yeah, I think if we're going to come back to this, I'll save my comments mostly for that. But I do want to point out that we do this currently in the medical space with medical cannabis. And so this is a deviation from current practice. And the commission has been responsible for following every gram of cannabis that's been going out there. And if there's an issue, then they can, they're supposed to be videotaped, they can follow up with prosecution. They can refer that to law enforcement if there's diversion concerns, and just, it gives me some pause to kind of move away from current practice.
I did. Thank you, but go ahead, Senator Hayes.
No, I was just gonna reiterate what he said, like, when, even now with medical,
Mhm.
and they buy it in bulk, there's a process already in regulation that the existing commission already have, where it has to be recorded, they have to, watch it and do that whole process already in the repackaging scheme of things. So it's already laid out in current regulation, to Senator Reedy's point.
So could he amend it to make it consistent?
You could, yeah, you could do whatever.
So Senator, was that an amendment that you were making to make it consistent with what we do for medicinal? Is there a second? Okay, I just wanted to hear, so we'll try to get staff to work on something, hopefully. But conceptually, we've heard from the committee. You got one. All right. So Senator,
Because again, I thought this was the work of the growers and the processors to package. And so are we saying that now they can take product out of the packaging that comes from the processors?
I think the recommendation that I've heard from your colleagues is that the process that is handled for medicinal in terms of that, which is handled through regulation from the commission, be the process that we start with as we incorporate this new, as we roll out this new program. By rollout, no pun intended.
Right.
I think what the suggestion has been is that we keep with current practice at the beginning. And then if it can't be done through regulation, that we come back and adopt something legislatively. Is that,
I'd just like to hear what we're doing with the medical cannabis to assure that that's the same,
It's authorized by regulation.
that they can repackage.
Yes.
Okay.
video? I'm sorry?
Somebody said earlier, it's all under video. It's all recorded as they repackage. It's very strict regulation.
That take care of your question? Oh, no.
I know.
Okay. Pick up the motion now or hold that and keep going.
It's up to you. Either way is fine.
Okay, we have a motion and a second before us to amend the amendments, which we haven't adopted yet. But that we will ask that the amendments remove the provision that disallows or prohibits repackaging, and that makes that process consistent with what happens for medicinal cannabis currently through regulation. Any questions on that motion? All those in favor, raise your hand. That is 10. Those opposed, raise your hand. That is 1. So that amendment is adopted. That is the only amendment we've adopted so far, by the way. Okay. And that's an amendment to the amendments we have in front of us. Okay, so we'll keep going.
Okay. So Amendment 5 in the amendment list begins on page 15. It adds clarifying language to the definition of control. And the House started adding some clarifying language, and the Senate has further clarifying language regarding what it means to have control for the purposes of selling equity shares for equity growers. It requires a cannabis business that converts a medical license to comply with ownership restrictions. It requires cannabis division to adopt minimum labor standards for employees. It authorizes the early transfer of a license in case of an owner's incapacity or bankruptcy or by court order. And also there's an additional exception here to the 5-year transfer requirement, providing for a exemption from the 5-year transfer prohibition for a certain settlement agreement. If the parties are subject to a settlement agreement stemming from litigation. It subjects licensees per the Attorney General's office to the state ethics law in addition to the ethics requirements in the bill, and also makes further technical changes. So that's amendment number 5. If amendment number 6 begins on some page, 18 begins on page 18. Amendment 6 phases in the authorized expansion of canopy for converting licensees to coincide with rounds 1 and 2 of the process established in the bill. It authorizes a conversion fee payment be made for those vendors who are, or for those licensees who are going to be required to pay such a conversion fee to be made in installments over 18 months. If you recall in the bill, every licensed cannabis, medical cannabis grower, processor, and dispenser is going to be required to convert to the new scheme under this bill, and there's conversion fees involved with that. This allows that conversion fee to be paid in installments over an 18-month period. It requires annual responsible vendor training, and the House added the, by the way, it was the House amendment that added the conversion fee payment. But the Senate has taken it a step further and will alter the conversion fees for already licensed growers, processors, and dispensers all in the same place. In the bill, it was in 2 separate places. The Senate amendments here will put it all in one place, and it says that the least amount of the conversion fee one of these licensees can pay is going to be $100,000. Between $100,000 and $2 million, which is the max any entity can pay in a conversion fee, will be $2 million. And between there, it's going to be 10% of gross revenues. So those will be the new conversion fees for all those who are required to convert if they still want to operate as a cannabis business in the state. Also, there's changes in Amendment 6 relating to the new fees for license grow for the cannabis businesses. It limits licensing and renewal fees licenses to the lesser of 10% of gross revenues or $50,000. And social equity licenses are 50% less than that. So whatever that amount is, it's going to be 50% less for a social equity licensee. Also, there was some issue relating to the timing of renewal fees versus the conversion fee. And there's language in the amendment that says licensing and renewal fees will be credited against the conversion fees. So people don't have to get hit twice if they have to convert. On Amendment 7, which starts on page 21 of 51. Most of these are from the House, and they clarify provisions on round 2 licensing to conform more closely to federal anti-discrimination case law, because you don't want to run afoul of that in these instances. And also it adjusts the conduct of round 2 based on an ongoing disparity study of business discrimination. Also added in this section, since we're talking about problems or potential conflicts with anti-discrimination and various constitutional matters, per the Attorney General's office, the disparity requirements, which are uncodified language in the current bill, are going to be codified in this by this amendment. So the disparity studies will be easily accessible now. The requirements for these studies will be easily seen rather than having to filter back through chapter laws to find them in uncodified language. So it codifies that disparity study requirement. Amendment number 8 starts on page, on page 24. Somebody's ahead. Is reading ahead. Amendment 8 limits the authority of local government to treat cannabis businesses differently than other businesses with a similar impact with respect to licensing, operating, or other fees or requirements. This is from the House. The House also amended the bill, and it's in this packet, to prohibit a local government from taxing cannabis. It specifies that. And then these are changes that the House didn't really make any changes here. This increases to 35% the money for the Community Reinvestment and Repair Fund. It increases to 5% the monies from the tax that go to counties and authorizing them to share with municipalities. It increases the public health fund to 5% from these business or cannabis business revenues, and 5% to the business assistance fund. It also sets the state sales tax at a constant 9% going forward. The House had it beginning at 5% and going up to 9%. This sets the sales tax at 9%. That's amendment number 8.
Senator Hershey.
Just real quick on the splits for government. So that goes from 1.5% to 5. And then it is strictly based on the volume of sales that happens in that municipal or jurisdiction. So I guess the comptroller or I don't know who does this, but is this from the commission or the administration now, or is this determined by the comptroller, or it might not even matter as long as
Yeah,
it's done?
it's gonna be, it's gonna be,
Okay.
it'll be done by somebody.
But they'll track the amount of sales that goes on, let's just start at the county level. And then tag on 5% of that will go to the county, and the county
The county may
share
with
some of that
municipalities.
with the municipality. If I guess the dispensary is in that municipality.
Yeah.
Is that right? Okay. Thank you.
Okay, let's go to,
Senator Kramer.
Thank you, Madam Chair. Can we just go back to revisit a moment what Senator Hershey said? The 5% that relates to the sales of the product within a jurisdiction, or just gross revenues?
looking at the, I'm gonna go to the reprint on this one, because that would be on that's on page 81.
Where does it make any reference to the percentage comes back?
Based on a
page
percentage of revenue collected from that county, yes. So it doesn't.
Page 80.
Mhm.
So if, for instance, of the 100 million that comes into the state on, and is this based on gross sales, gross income? What is the basis for, is it gross income after you take out whatever it costs to do the administration? How is it broken down?
I think it's just 5% of whatever they collect in sales tax from that particular jurisdiction.
So it's not 5% of revenues. The jurisdiction gets 5% of whatever the sales were generated within Prince George's County, let's say, or Montgomery County.
It's got to be 5. Correct. The sales tax is collected based on the total amount of sales at 9% now.
Yeah, if you
right?
go to the top of the page, it's up
Right.
there.
Then that's the pool of money that they start splitting up.
Yes.
And of that 9% of sales, 35% goes to reinvestment, 5% will go to the county. But in that case, it's allocated based on the sales of each county.
Right, so that's
Right.
what I'm trying to get a handle on. So where we have, for instance, the 5% that'll go for now the public health fund. That's out of the total 9% sales tax. But now we've got 5% going to each jurisdiction based on that jurisdiction's percentage of the 9% sales tax.
Or whatever revenues came from that particular jurisdiction, that's how it'll be up to the total of 5%.
So it's not guaranteed even to be 5%. If the sales that came out of that jurisdiction were nominal, what do they get? Do they still get 5% of the total pie? Or only based on what was generated within their jurisdiction?
Yeah, if I read this, how it works, 5% will go to the counties, and then from that pool of 5%, based on the sales of that's how that money will be distributed to the counties.
If you look at it as different buckets, right? So 9% gets collected based on all the sales. Then you then you take that and you split it up into one bucket's getting 35%. That gets split up
And
somewhere.
one bucket's gonna get
One
5%.
bucket's gonna get 5% and then.
That's for the counties.
That's for all the counties.
And then within that one bucket of 5%, they only get back a percentage of what the sale, whatever the portion of percentage was. So they're not even getting 5%. What I'm trying to get to is,
It would still equal 5% of the sales that was in that. 5% of the bucket, right?
they get their percentage of that
They
5%.
get a fractional percentage of the 5%.
Correct. That's
Yes.
my
Yeah,
point.
it's
That's
a
what I'm
very little
trying to
amount of money.
get to, which means the counties are still going to be coming up with probably not even pennies on the dollar, but percentages of pennies on the dollar in the whole revenue picture. That's kind of what I'm trying to drill down at here. So I guess we'll have opportunity for discussion on that.
Correct. And what I would say is, I think that the amendments that we have before us are a reflection of a desire to move that up from what was a 1.5% as the
Granted.
bill was brought before us. So acknowledged. Okay, Senator Hayes, were you?
We'll come back. We'll be able to have opportunity to further discuss.
Sure.
Okay.
Senator Hayes?
Thank you, Madam Chair. David, did we define counties in the legislation? I'm curious specifically about Baltimore City. It's neither a municipality.
It's
Nor a
considered-
county.
It's always
But-
considered a county.
Okay, because subdivision is defined,
Yes.
but not so much of a county. so-
County is always, county is a county, and it almost always includes Baltimore County unless you want to be separated out.
Right, no, I know in the code, it's always defined as county, so I wasn't sure if we redefined it separately. There's a big bill, a lot to go through, so I didn't have time to see all of that. Thank you, appreciate it.
Okay. So the next amendment is Amendment 9. This is a long one. Bottom of the page. Let's, yeah, and yeah. So this amendment caps the amount of the qualified partnership grant at $250,000. It further expands the criteria for disproportionately impacted area. It adds attendance at certain schools to qualifications for a social equity applicant. It requires the cannabis division, which is now going to be, hopefully, if this bill passes, the Cannabis Administration, to develop a process for home growers and qualifying patients to obtain propagation materials. And the House required it just for home growers generally, but qualified patients under this bill are also going to be qualified to grow cannabis. It requires the banning of internet sales by the administration. It provides that a license does not confer a property right. It prohibits non-converting license holders from operating, but allows the non-converting license holder to sell the license with conditions on the buyer. This is a Senate amendment. This is from the Finance Committee or the chair. It authorizes an existing licensed dispensary to continue delivering medical cannabis until January 1st, 2024. It prohibits the conduct of a market demand study before the first round of licenses are issued. It sets the number of micro dispensary licenses from 75 to 10 in the first round. Also, I might as well point out here also, that is the only number of micro dispensaries in the chair's amendments that will be authorized, just 10 in the first round. Where am I? It requires dispensaries to have shelf space for products from other growers and processors that do not share a common owner. Per the administration, it makes clarifying changes to language regarding incubator licenses. In the bill, there was language that required Medco to go out and look for sites to start incubators, so folks can be, you go there and then you learn how to work in the industry. And the bill also would have required Medco to own the property, and that's not appropriate for Medco. So once this site is identified, it would be run by the Department of General Services. These are amendments from the administration.
Senator Hayes?
Yes, thank you, Madam Chair. David, you, in the beginning, I know this is a humongous amendment for you to review, but you had mentioned something about the disproportionately affected areas, and I've had a hard time trying to locate that in the beginning, in a very, very beginning part of your description. You mentioned something about disproportionately affected areas.
I think it might be, in this case, it might be better to go to the, okay, yeah, if you go to, actually in the first page of the amendment in the middle, had above 150% of the state's 10-year average.
Okay, got you.
That's it alters what was in the bill and adds that language there.
Got you. Okay. Let me go to the reprint to see what it actually says. Thank
Okay,
you.
and on the reprint that's on page 22, yes.
Thanks, appreciate it.
Sometimes it's easier to go to the reprint because you can see the whole context. Okay, continuing on. It provides buffer zones to prevent clumping of dispensaries. And this should be spelled out completely in the amendment. Which would start on page 31, or actually 30 of the amendments on to 31. This is the amendment designed to prevent clumping. You'll see that no dispensary can be located within 1,000 feet of another dispensary. They have to be at least 500 feet away from pre-existing schools, licensed childcare centers, and playgrounds, libraries, etc. There is an exception if the location of the dispensary is already there because of proper zoning, then they would not have to necessarily comply with this requirement. So it would allow the dispensaries to stay where they are if they're there properly.
Senator Ellis?
Yeah, thank you. I know the discussion previously in a lot of circles were about also restrictions on places of worship when it comes to dispensaries. A lot of constituents are concerned about cannabis dispensaries like liquor stores being right next to places of worship. Is there any rationale for not including places of worship in the restrictions on locations?
No, there is nothing in here about adding places of worship to the buffer zone requirement.
Okay. Is there any constitutional issues you think about excluding places of worship? I know when it comes to religion, it's always constitutional issues there. I'm not sure if the council can address that, or
I don't know if there's you always run into an issue regarding defining what is a place of worship. I know that could be a problem, but I don't know if there's any other constitutional issues with adding them to the buffer zones. No, I'm not aware of any. I could find that out for you.
if you could, please.
Okay.
Thank you.
Okay, Senator Hayes?
Madam Chair and David, for your indulgence. I went back to page 22, lines 19 down. And I was looking at the definition here. It says had above 150% of the state's 10-year. I'm not sure what that means. When is the 10-year average? Is that new language
That's added by the House.
added by the House? And they don't know. So is it 10 years from now? Is it?
I believe I started looking into this. I believe they started collecting the data in 2010.
So whenever they
So
started collecting.
when they started collecting the data moving forward and having talked to colleagues in the House, there is a impacted area in almost every jurisdiction in the
Right.
state by zip code based on the concentration of the number of possession arrests in those areas.
Thank you, appreciate that.
Mhm.
Okay, so find out about churches. Yes, I'm making a note. Okay, also, under the capital access program, it sets the loan amount limit for social equity dispensaries at 500,000 and for growers and processors at $1 million. And it increases to 5. In the back of the bill, there's uncodified language relating to a settlement, discrimination law case. And it increases to 5, the applicants that shall be issued grower licenses under that specified litigation. But there is a language in the back of the bill that from the Attorney General to make sure that all these changes are constitutional. So there's alterations to that language regarding the Pigford litigation to make sure it meets constitutional muster when you say that these folks get that some of these folks who are impacted by that decision can get 5 grower or processor licenses. Amendment number 10 begins on page. Thank you, Senator Kramer. Okay, this is a pretty short amendment. It strikes provisions on the construction of the licensing statute in relation to property use, operation of a motor vehicle while impaired, and cannabis use in public and in a motor vehicle. It also strikes civil immunities and liabilities and authorizations relating to professional licensing, denying employment, and authorizing drug testing and other related matters.
Senator Kramer.
So David, exactly where do we stand? Is this where we have the provisions for what a business may do to ensure that their employees are not under the influence or intoxicated by cannabis? What ended up happening? I know that there were some things that came out. Did anything go back in?
Nothing went back in. The house, these are the house, this is the house action. It strikes these immunities. My understanding is and from the Attorney General is that the current laws relating to drug testing would all still apply regardless of the circumstances of what's put into this bill. So this makes no changes to the current requirements for substance abuse testing and under the Health General article, which is 17-214.
And under that article, it is permissible? Is it required? What are the?
It's permissible to substance abuse employees under the circumstances specified in that law. And there's also, it has to be in conformance with federal standards too regarding what substances can be tested for.
Okay, and that should be sufficient to protect employers who are looking to protect themselves from litigation and liability. Is
That's
that
the thought. I can't say it's the intent, but that's the thought of the Attorney General. Yes.
that article is
Yeah,
sufficient?
yes.
Okay, thank you.
It's House General 17-214. Is the state law that authorizes substance abuse testing.
I'm sorry, we referenced, I missed it. We referenced that here.
No,
Do we
we don't
cross-
reference it. It's just, it's already existing law, so there's no cross reference to that.
Why aren't we referencing that to make people more comfortable that we have addressed it since it was purposely taken out? I thought the thought was that we could cross-reference that law to, again, to show that we have.
Yeah, there's nothing to cross reference it to.
I think when that provision is removed, there's nothing to attach that reference to.
I think this was one of the issues that came up an awful lot when we were talking about it over the summer and the past year as well too, is to make sure that businesses had some way to continue to protect if employees came in impaired. And a lot of employers still, have drug testing that they're still allowed to do. And that's why it was written in here that that was still going, well, that we were talking about doing that. So is the feeling that we don't have to reference it and every employer can just stick with whatever that's been done, and there's nothing in here that would let an employer know that they can't do that anymore,
Correct.
even with it being now a legal product, right?
Yeah, I think similarly, alcohol is a legal product. Yeah. So I think the feeling is that because existing law already speaks to it and employers are already protected under existing law, that we're not differentiating this from how they currently practice and the rights that employers have. Correct?
Just want to make sure that everybody's intent is that that's what can still happen. So, okay, thank you.
Okay. Amendment 11 starts at the bottom of page 33. And again, these are largely House changes to the chair is offering on this bill. It makes cannabis, the Cannabis Regulatory and Enforcement Division report directly to that's actually going to be gone now with the changes coming in another amendment. It allows rather than requires the executive director of the Alcohol Tobacco Commission to be a sworn law enforcement officer, and it provides that a non-sworn executive director is in the regular employees pension system rather than in the law enforcement's pension system, and alters the makeup of the advisory board on the medical and adult use cannabis. Amendment 12. That ends pretty much the House amendments that the chair has offered to the Senate bill. So Amendment 12 begins on page 30, yeah, right again. So Amendment 12 restores the original language in the Community Repair and Reinvestment Fund. The bill is introduced, made some changes, and it puts the original language back, and it also changes a word to harm instead of impact. So that's in this amendment. It reduces the number of as I mentioned earlier, the House reduced the number of micro dispensaries to 10 in the first round. This amendment completes this process and makes it 10 period going forward, and requires the department or the administration, if it becomes an administration, to provide an update on how these dispensaries are going to operate. And it also increases the number of dispensaries that may be held by a grower, particularly one who is converted to 4. The bill brought it down to 2. This restores that number to it makes it the number 4 now. It limits canopy growth over the period from conversion to 20%, and requires an assessment. And it requires, here it is, the assessment of micro dispensary capabilities for reporting to the General Assembly. It clarifies that a license is required before operating an on-site consumption business. This is for the purposes of a regulation of these on-site consumption businesses. It allows licensed cannabis businesses to put up a sign on their property. The language and the bill is introduced prohibited any type of signage regarding cannabis, and it would allow these licensed cannabis businesses, similar to the medical cannabis law, to put a sign on their property. It defines THC and tinctures and related matters to allow the use of tinctures and subject these products to state regulation. This gets at the hemp issue.
Senator. Yep. We're on page 39.
Yeah, and that should all be that should be in the entire amendment. If you go to page 39 of the amendment, you'll see a definition of THC at the bottom, or no, I'm sorry, at the top of on page 38. This begins that whole section. So when the bill is introduced, it just said it prohibits the sale of Delta 8 and Delta 9. This takes it much further and defines hemp. It defines THC, which is at the bottom, which is tetrahydrocannabinol, to include Delta 9, Delta 8, and various other types of deltas that may come along. And it also defines tincture. which is a solution that is dissolved in something and distributed in a dropper bottle of 4 ounces or less, and then it would subject all of these items to regulation by the proposed administration.
Got a few. All right, so David, as I understand correctly, what happens with, well, what happens with on-site consumption? Did I understand you were just addressing that in this amendment, or am I mistaken?
That was a part of this amendment. That was a clarifying amendment to say that before an on-site consumption can be vetted by anywhere else, that they have to have a license from the division or from the administration.
And where and how is on-site consumption defined or permitted? In other words, I know with, for instance, cigar shops, if you have a cigar shop, we provided the opportunity to sample a cigar and smoke in a cigar shop. Are there going to be any opportunities, for instance, a restaurant to have on-site consumption, or
The
what?
the bill is structured, does give authorization for an on-site consumption to obtain a restaurant.
To a what restaurant?
To obtain a food service facility license. But generally, the on-site consumption, they have to have a license from the division. They're highly regulated. They cannot, there's no alcohol allowed, no tobacco allowed. Only whatever is authorized by actually the local jurisdiction. The local jurisdiction can control where on-site consumption entities go, and they also can determine what can happen at an on-site. That's all authorized under this bill, that they can determine what on-site consumption means in that particular license.
Okay, so this unequivocally provides local control over on-site consumption.
Yes.
Okay. Number two, what does this do with regard to our laws prohibiting, for instance, where we did not want tobacco smoke in restaurants and exposing employees to that? Does this kind of blow all that out of the water if these on-site consumption facilities can have a food license?
This, again, you know, you're not required to work there, but there is a language further on in an amendment, because it came up about whether you could, you know, how would this interact with the Clean Air Act?
Right.
So I didn't get there yet, but on the end of the last change to Amendment 12 is it specifies that an on-site consumption businesses are exempt from the Clean Air Act. So
Really?
This would provide a specific exemption similar to cigar bars that that they could smoke cannabis at these facilities.
Did this come over from the House like
This did
that?
not come over from the House.
It did not.
No.
This is something that appeared in the Senate
This is something that is in these amendments, yes.
and would allow that exempts them from the Clean
Technically-
Air Act.
Technically, they already are exempt. This just makes it clear, because when the state authorizes a separate license in law, they can, and authorizes a certain activity at these establishments, it by the General Assembly understanding what it's doing and what they can do, they would have been exempted anyway. This just makes it clear by providing the exemption under the Clean Air Act.
So if we didn't want that to violate the Clean Air Act, then we would have to specify that this has to comply with the Maryland Clean Air Act. How would we?
I would consider that clarifying, because the fact that if this bill passes and you authorize a license, there would be no conflict with the Clean Air Act, because you're knowingly passing a law that authorizes certain actions under a license. And it's a licensed entity too, so they would have to get a license from the state before any of this can happen, and from the, they have to be authorized by the local jurisdiction before any of this can occur, any of these activities at a.
But my understanding is, just so I'm fully clear on this, under whatever the amendment is, you said amendment 12 at the end of it,
Yes,
we are granting an exemption.
yes.
All right, what page is that on? Can we flag that, please?
In the amendment or in the bill?
In the amendment. Page 40. An on-site consumption establishment license under the alcohol, that's the exemption?
Yeah, that's the Clean Air. That's a section of the Clean Air Act that provides exemptions under the Clean Air Act.
And is that the only language,
Yes,
if I understand correctly, that provides the exemption? Were this language to be stricken, then they would have to comply with the Indoor Clean Air Act? Is that?
No, again,
Okay.
by establishing a license, separate.
Well, that's what I asked a moment ago. Do we have to specify that they must comply with in the bill?
In the bill? Which,
Is you're showing where you have exempted
Page
this from
70.
the Clean Energy.
it's in
Clear
it's
Act.
in the back of the bill on page, on the reprint on page 70.
85.
See where we added the language that exempts it from the Clean Air Act.
Yes,
Okay, so that's 24,505, I guess, is the Clean Air Act.
yes. That's the
Okay.
only place where that will show up in this bill.
Where else does it talk about on-site consumption?
Oh, there's a separate license in
Right,
on-site consumption, and it's in
where's that?
it's on it's on page 50, happen to be right there, page 50,
Page 50 of
the reprint.
the reprint.
So you can see all the things that on-site consumption would have to comply with to get this license.
So we don't do that for tobacco, but now we're going to do it for cannabis, if I understand correctly.
Well, I mean, tobacco stores are already, they're already not subject to the Clean Air Act under current law.
Only cigar shops.
Yes,
Okay. But this is going to allow, and correct me if I'm going down the wrong path here. We're going to allow food facility licenses to be part of a cannabis license. And that means then if we've got a restaurant where they have cannabis, they're going to be smoking cannabis. Am I right or wrong?
I thought there was something in here about, maybe I could have been mistaken.
Why are we going to have food facility licenses with cannabis licenses?
No,
if
it's
they're not-
on page 51, a food service facility as defined may apply for a license to operate an on-site consumption.
So then we are also violating the Indoor Clean Air Act in restaurants. Am I mistaken or what am I missing?
You're not violating it because you're establishing a specific license to authorize an on-site consumption.
Okay,
That's
so
my-
it won't
that's
be
my problem.
it'll be a legal violation, in
It's-
other words. So we're going to permit, what we're going to do is now where we have prohibited tobacco smoke in restaurants, we're going to allow cannabis smoking in restaurants if they have this appropriate license.
If they get a license from if they get a license from the division or the administration and they get authorization to open from local government, yes.
Okay,
And they also have to get approved for a food service facility license from the health department.
yeah, okay, so it's just a matter of getting licensed and then they are now able to do something we prohibit the restaurants from doing with tobacco. We just have to get the right license. Oh, yeah. No, I'm just trying to make sure you're all on the same point here.
All right, Senator Guile, you've had your hand up for a while, your light on, and then we'll go to Hershey, then Lamb, then Vital.
Thank you, Madam Chair. And David, so I'm understanding this correctly. Are you saying that if we, back to the Clean Indoor Act question, if we have this, if we authorize this by this law, then that creates an exception under the Clean Indoor Air Act, even though it's not explicitly stated within the Clean Indoor Air Act.
Correct.
I feel I have a little bit of discomfort with this and partly, I guess, because it just seems to me a bit of like lack of clarity for anybody wanting to understand. You know, I think there's been some ambiguities that have already been raised, you know, so far this session, including on the cigar lounge topic about the Clean Indoor Air Act. And I just have some concern about it. And yeah, that's just my comment about it. So thank you, Madam Chair.
Thank you. Senator Hershey.
Thank you. So I'm going down the list of things that a consumption establishment may not do. But what I'm trying, can a on-site consumption license allow you to sell cannabis? Right, does this become a dispensary?
I think you can, I believe they're authorized to sell, only to people who can, consume on site. I don't think you can walk out with it.
All right, because I'm trying to figure out the business model of this thing, to be honest, how this is gonna work. You know, we're gonna rent some place, invite a whole bunch of people in to come and smoke, but yet I'm not sure if I can sell it to them, or I still need a license, but how am I making any money by having this establishment so people will come in there and smoke? Or is it my next door neighbor's house? I mean, it could be anything, right? I mean, all you have to do is get a license for it, but what's the business model to say, hey, this makes sense for someone to open up one of these things if the product can't be sold to them, or it can be? Okay.
I can't, I don't, it's in the bill.
But you're saying, I guess to clarify, there's a couple, so an on-site consumption may sell product to those that come in to the establishment, right?
It says it authorizes the entity to distribute cannabis or cannabis products for on-site consumption, that they have a license.
Distribute. Says they can't give away free, but they can distribute.
That's on C1. On page 50.
I assume distribute means sell,
And the bill is introduced.
because, well, I guess it has to, because the next page, it says that they cannot distribute or allow the distribution of free samples of cannabis. So this would now be an entity that, let me just ask another question. So does this entity, does an on-site consumption license have to go through the same process and then be a dispensary?
They have a separate license with separate criteria which will be governed by the administration.
Because that's how I'd open a dispensary. I'd say it's an on-site consumption place. I don't have to go through all the dispensary applications and fees and all that kind of stuff. I open up an on-site one, I'm allowed to sell whoever walks in the door. Is that right?
I can't speak
I'm not
for
trying to
what,
put- yeah.
I can't speak for what regulations would cover or what they would involve the use of product in these facilities.
Okay. Thank you. Noted.
Noted. I wrote down my list of who was next. Senator Lamb.
Thank you, Madam Chair. I'm candidly a little surprised with this amendment. This is
Is this an amendment?
not what I was expecting would come out
This
of
is
the
the
on-site
bill.
consumption
This is the
piece,
bill.
and
They're
particularly
doing that.
this
This is the bill.
exemption to the Clean Indoor Air Act. I think it's important to point out that cannabis smoke also carries the same risks as cigarette smoke. And so, creating this huge loophole in the Clean Indoor Air Act gives me, a significant amount of pause to look at this. And my understanding was that the Department of Health was actually intending to continue to enforce the Clean Indoor Air Act on these facilities as well. I would be curious to hear from the department what their intentions are to this, because this seems to be running counter to my understanding of what the department was intending to do with the Clean Indoor Air Act. So, I think all of this is creating a huge loophole in the Clean Indoor Air Act that I'm
Noted.
not particularly
Noted,
comfortable with
everybody.
this. So,
Noted,
Okay.
noted. I'm gonna call on Senator Beidle, who hasn't spoken on this issue, and then we're gonna come on this side of the room and let a few folks weigh in. And then we'll see if perhaps we have a motion, or if we want to talk about this further. Senator Beidle.
Thank you, Madam Chair. And I share the same hesitation, but in the House bill that we brought over amended, it said 15 on-site consumption licenses. In two places, it says 15. So I think that means 30 altogether. Is there a micro license and then another license that each allows 15?
I don't believe there's micro on-site consumption licenses, so,
Page 52 for micro licenses, 15 on-site consumption licenses.
no, there are.
And then on the next page on 54, it says 15 on-site consumption licenses. So-
Okay, if you want to find out exactly how many are authorized in the state, then you go to the first part of the licensing, which is on page, in the reprint, that would be on page 50, there's 50 on-site consumption licenses authorized statewide.
50. And so that includes all of those ones I just asked about.
Yes, that would include all of those. So on page 38, that's the total number of licenses authorized in the state for all cannabis
Well,
businesses.
I just want to share the comments of my colleagues or agree with the comments of my colleagues. Thank you.
Noted. All right, we'll go Senator Hayes, then Vice Chair, then back to Senator Guile.
Thank you, Madam Chair. Look, not that I'm trying to attract the extra attention of the Maryland Cancer Society, but from my understanding around this language, it derived from the concern around folks that are in rental units that share a space in a multifamily dwelling, not having the ability to share in that smoke. And so the idea around this was really around an equity issue, providing a space whereas individuals can safely consume. Not that I'm justifying, but this is my understanding of how this came to be included in this piece of legislation.
That was my understanding as well. As a matter of fact, when I first heard it, I had a reaction similar to my colleagues. And then after hearing that, for those who live in multi-family dwellings and folks being concerned about aromas going through to neighbors' houses and things like that, that this was a proposed solution. And when I looked at the number and saw the 50, I thought about how many legislative districts there are in the state and said, okay, so everybody could at least get in an Uber and go to a place and do this thing that the voters have decided is legal and then get back home. But I shared your understanding, and I'm not trying to attract the ire of them either. Vice Chair.
I'm duly noted what you originally said, but that makes sense. But I just question this. I mean, I never wanted it in the first place. And I guess I won't be visiting in those establishments. I'll stick to the bars where they just have beer and that's it.
Okay. Were you Senator, you're done? Okay, then I have Senator. Yes, no, light on. Okay.
No, I was just going to echo it. It does give me some discomfort about having these on-site consumption locations. I do recognize the discussion that we've had on this topic about hearing from constituents or concerns about use in multi-unit housing, as well as parks, public spaces. At least, I mean, if we deny an opportunity for a substance that I guess has been made legal, but balancing that, I understand both perspectives. It just does still give me a bit of concern. So thank you, Madam Chair.
Thank you. We'll go Senator Kramer, then Senator Lamb.
All right, well, my question of the chair, are you interested in entertaining an amendment that would strike food service facilities having an opportunity to get a license for on-site consumption. Because for me, then, you know, that's a significant issue because we're clearly going backwards with regard to our efforts in the Clean Indoor Air Act, if we're going to do that. And then I guess an additional amendment would be required to strike the amendment allowing the exemption to the Clean Indoor Air Act. My intent here, if you're following my intent.
I am. If I could, let me hear from Senator Lamb one more time, and then we'll
Sure.
come back. My inclination is towards the language, which I think is giving folks the most pause, which is the language with the exemption related to the Clean Indoor Air Act. But let's go to Senator Lamb.
Yeah, I mean, that does give me pause with the exemption piece. I think, you know, I understand the concern with multi-unit dwellings, but I also have concerns about how, and that's why we allowed for these on-site consumption licenses, but then to allow for them to also be serving food as restaurants seems to be a step further than I was expecting this to go. You know, I think these licenses actually they don't kick into effect until 2 years from now. So, you know, I think if there's some concern, maybe that can be addressed in a subsequent year without opening this loophole up right now. Because we would still have time to be able to deal with this later. The other thing to keep in mind that's important is that the Clean Indoor Air Act is for indoor air, right? It doesn't restrict what can take place outside of the external to the facility, external to the walls of the facility. So if there's some need for people to, you know, have on-site consumption outside, that would still be exempt from the Clean Indoor Air Act. I want to make the Clean Indoor Air Act as airtight as possible. I have an amendment too to make that very clear in the bill, but we'll
Thank you.
proceed with Senator Kramer's first.
Thank you, Senator. Can I go to Senator Mounts?
So with this amendment, just to clarify, an on-site permit could be issued. But the smoking would not be allowed to occur where the eating is occurring. But the on-site consumption would still be able to acquire a food service facility permit. So by eliminating the exemption, so to sort of break that down, if there's an outdoor smoking area or a smoke room separate from where the food is being served, the entity wouldn't be prohibited from acquiring a food service permit and an on-site permit.
There's two parts here. There's one where Senator Kramer has proposed striking subsection D. And on page 51 of the reprint. And then there's also the added language on page 40 of the amendment on the top of page 40, which provides the of the amendment.
Of the amendment, of the package of amendments or the reprint are you talking about?
I'm talking about both, because one's not in the reprint. Or one's not in the amendments. One's only the language about the food service facility. There was no change to as the bill came across, and the House made no changes to that also.
Okay.
So that's the original language in the bill, and that's on page 51. That's subsection D. And then in page 40 of the amendments at the top, that's the language that provides the exemption from the Clean Air Act. So there's two separate actions here.
Senator Mounts, does that take care of your question?
Kind of, I'll keep working on it.
Okay,
Yep.
so Senator Kramer, oh, wait, I'll go to Senator Reedy and then come back to.
So are we talking about amending this so we get rid of the food service entirely?
Senator Kramer, I believe, proposed a removal of the exemption from the Clean Indoor Air Act
Right.
and a removal of the food service facility lines, which came in with the original bill. Was that your request?
Yeah, so there's two issues here. One is that restaurants will be able to have on-site consumption, so they'll be smoking cannabis at restaurants with the appropriate license, which we do not permit any longer for tobacco. So it would be consistent with what we're doing with tobacco. And then the other is this, just carte blanche exemption to the Clean Indoor Air Act. So there's.
Because, and the reason I asked that question is I think both amendments are good because we didn't there were a lot of bars. I remember I was a staffer here when we passed the Clean Indoor Air Act. And it was ruthlessly passed in the sense that we got to get cigarette smoking out of the bars and restaurants. And, I wasn't a voter. I didn't get to vote on it. Obviously there were the typical arguments about businesses being able to do what they want to do versus not. And we made a policy call as a General Assembly not to allow that. So it seems we've not passed a bill in here to allow for a liquor license for a particular establishment in one area of the state because there are concerns about violating the Clean Air Act. To me, that amendment is really good. I don't think we want to have. I'm concerned about both of those issues. I mean, I think Senator Kramer is right. I don't think we should have, food service folks getting into this space. So
that's a second.
I guess that's a second. And can I make one other point? Just one other point on this entire issue, and then I haven't said anything this whole time. Is smoking the only way to consume cannabis? No, it is not. In fact, some of these gummies look very tasty. I've never had it. So if you're in a multi-unit housing, I would bet it might even be cheaper, although I don't know what the pricing is. So if you're in a multi-unit housing, this issue of equity, nobody's stopping you from getting high recreationally, but you could take a gummy instead of, and it's very tasty. I imagine.
So you heard.
I've never had it.
So I'm going to ask, since we do have a motion and a second, that we separate those two amendments for vote, because I'm going to have to, as much as I do not want to put myself on blast, I'm going to have to say that I don't want to decide for someone how they should consume this substance that we've all decided is legal. And so I do hear all of the concerns. I don't want to go to a cigar bar, but people like it and that's their thing and they can do that and it's legal and they do it. And so I'm going to ask that we do separate votes on the restaurant piece and because I'm not sure, and I want to ask council, if we were to adopt the amendment striking the Clean Door Air Act language, would that then say that those licensees that are allowed to have on-site consumption, the people that are at those sites would not be able to smoke that at those sites if we pass that?
In the bill, not in this part, but in the bill, smoking is authorized in an on-site consumption facility. My conversations with the Attorney General said that if the General Assembly passes a separate license for something like this, then the requirements of the Clean Air Act would not apply, and you would be if they're authorized to smoke at an on-site consumption licensed business, they could do that still, regardless of the Clean Air Act.
Okay. Senator Lamb.
I just want to very briefly speak in favor of the second, well, I guess in both amendments, but particularly the second amendment where we're removing that exemption. I think the concern is that if we allow for an exemption, everyone will come forward to this committee in future years asking for exemptions to the Clean Indoor Air Act. We will not see the end of that parade.
Okay, Senator Hershey.
I'll just add to support that. If you read all of 24-505, the reason we allowed the exemption at the tobacco places is because they sold it there as well. And that's specifically written in that the primary activity is the retail sale of tobacco, and then the sale of other products is incidental. So that's why we allowed it. This is not talking about any of that. So
Gotcha.
I just think we need to scratch that.
Understood.
Thank you.
Senator Ellis.
Madam Chair, this is a kind of a conflicting vote. Okay, so this section was put in order to take care of the issue with multifamily housing. And there was a huge debate with that, I know with my colleagues. And so if we take that out, I mean, what will we put in its place to address the multifamily housing and the smoking of cannabis in those facilities in that I don't think we're in a position to say, use gummies.
No, my
Oh,
under, my understanding from council is that striking this provision still allows for that on-site consumption at that limited number of locations that are in the bill. So we may not need to separate it. This is speaking to this particular. So the language that would stay in the bill puts those on-site consumption sites similar to the tobacco or the cigar places that we have. Okay? So do you want to go ahead and take up this motion? Do you?
Which one are we?
So, well, I think we can take them together now that we understand that that means that we're not telling certain people how they should consume, right? Okay, so I have a motion and a second on the singular amendment that Senator Kramer has offered that would take out the provisions on page that
Page
related
4,
to the restaurant,
Okay, that's on page,
Partaking.
that's subsection D on page 51 of the reprint.
and the open air,
And the
Clean
yeah.
Air Act. The reference to the Clean Air Act in this,
And the amendments.
Food service license out
And
and
Clean Air, correct. I could make a joke right there, but I've learned not to try to be funny. Okay, so we have a motion and a second on language to remove the restaurant on-site consumption and the exemption from the Clean Air Act. Senator Kramer,
I'm in favor of that.
you did. I had a motion and a second, so I saw your light still on.
No, ma'am.
Senator Guile?
No, I just have a quick question because I can't help but think of munchies. And but by removing if one again if we move a restaurant, like, they can still sell food, right? You can sell chips or something there. Is that right?
Okay, so Senator, what I would say is it is not clear on that, but these licenses would not be available until May of 2024, if I'm understanding anyway, for the on-site consumption. So we don't have to address the snack food amendment at this time. That's next year's bill.
Thank you, Madam Chair.
I understand there's some companies across the state, but never mind. Okay, we have a motion and a second for a favorable on the Kramer amendment. Does everyone understand what the amendment is? Everyone understand? No further questions being seen. All those in favor of the amendment, raise your hand. That's 1, 2, 3, 4, 5, 6, 7, 8, 9. Those opposed, raise your hand. 1, 2. So that's 9 and 2. That amendment is adopted. Okay,
Okay, we're going to continue. It's 5 o'clock.
Senator Hershey?
I guess we're gonna be finished soon, but can we get clarification if one of these on-site consumption locations can sell product?
Yes.
I'm looking to get, and if they can,
Wait a minute. You mean the on-site consumption that was in the bill as introduced, not the restaurant ones that we just struck?
no,
Okay.
the sites as introduced, can they sell product?
When you say product.
Pot, I don't know, marijuana, cannabis, whatever, pick a name,
Don't know.
right? Well, that's what my question is, just to see if these are one of a handful of dispensaries that also allow smoking.
They can dispense, they can distribute. So it's a question of how do you define distribute?
Okay.
That's all. Okay, thank you.
Okay. Where are we?
We're on amendment 13.
What page are we on?
And yes, that starts on page 40. And these amendments, this amendment does two things, but it runs pretty long. It runs from page 40 through page 43. And it requires potency limit requirements and packaging labeling requirements. And it also requires an annual report about cannabis products rather than every 2 years. So that's all in this amendment 13. So if you look at the amendments, you'll see that it requires which will be the administration to adopt regulations regarding potency limits. And then there's a list from the bottom of page 40 all the way down about what packaging and labeling cannabis products must be in. It's a very long list of requirements and what's prohibited.
Goes all the way to page 40.
43. Okay. And next is Amendment 14. This makes clarifying changes from the comptroller regarding how money is supposed to move around. It also changed at the request of the Attorney General. It makes changes to the advertising requirements for cannabis products. And so that's what that does. And that amendment begins on page 43 and goes through page 45. So all the Attorney General changes are relating to the portion of the bill that involves advertising. Limitations and requirements for advertising on cannabis products. And Amendment 15 is the amendment, and that starts on page 45. This amendment changes the House made it a division of Cannabis Administration, or a division regulating cannabis. This makes it the Maryland Cannabis Administration and establishes it as an independent unit state government, and corresponding changes throughout regarding making the proposed administration a completely independent unit, separate and distinct from the Alcohol and Tobacco Commission. So they will be their own standalone governmental units, I guess, similar to the Insurance Administration. Regarding the regulation of cannabis.
Senator Reedy?
Remember this issue. So are they still under the commit?
With this amendment, they will be separate and not under the Alcohol, Tobacco, Cannabis Commission. They will be separate. That will be an advisory body. They will be a separate state entity under this amendment.
For the purposes of, are they regulating the licensing, all of that? They're not doing the regulation of, they're not doing the regulation of the product or the potency or the.
Yes, the administration will be doing everything that the division was going to do, but the division and the bill as it came across was housed underneath the Alcohol Tobacco Commission, and they structured it such that there was 3 separate entities with no. It was kind of a bureaucratic muddle. So this amendment proposes to just take them out and make them their own separate state entity, fully responsible for the regulation of cannabis and enforcement of cannabis laws in the state.
Okay.
As they relate to regulation, not the criminal stuff.
And is there be a director appointed or a secretary
It
or
calls for a director.
will that director have Senate confirmation?
Yes.
Okay. Great. That's fine. I was just trying to, I didn't remember that from the hearings on anything, but we may have come up. It's just we've had a lot of issues. So thank you.
Okay, Senator Kramer.
Thank you, Madam Chair. At what point would it be appropriate to be discussing other potential amendments or?
We still have one more amendment.
Oh, I'm sorry. I thought we were there.
Now you have Amendment 16, which is all uncodified language in the back, and most of this was added by the House. It concerns various studies that the new administration will have to do on wholesale markets, potential for incubator spaces, on-site consumption issues, and certain developing developing certain cannabis products. Also, at the very end of the amendment, there was an issue regarding HB2 growers. It gives HB2 growers the opportunity to apply for a dispensary license. If you got your license because of House Bill 2 in 2018, And it also says that if you got a processor license from House Bill, as a result of House Bill 2, you would automatically be included in the lottery for round one micro grow licenses. You would not have to go through the pass-fail vetting of the administration. It would just be an automatic inclusion in a list of folks who could be in the lottery for a micro grow license. Well, they would apply and be granted a dispensary license. Yes, yes. As similar to what the original growers were offered in 2015. They were offered the ability to get a dispensary license. Some of them took the state up on that. This offers the same opportunity to the social equity group growers who got licenses in 2018. And that's it for the amendments in the amendment packet here.
Okay, so that Senator Mounts? No, okay. So those are the 16 amendments on 51 pages that we presented for your consideration. And that is with the modifications that we've made, beginning with removing the credit unions all the way to the very end, right? Senator Reedy?
Just gonna echo my friend Senator Kramer's question, if it's the appropriate time for amendments, but I defer to him.
Oh, okay, yes.
Yeah.
I'll go to Senator Kramer.
Do we want to move these amendments first? Yeah.
Yeah, that's and then.
Can we take up the committee amendments first? I'll entertain a motion. Have a motion
Move favor.
and a second for a favorable on, that was Senator Ellis and the Vice Chair seconded. On the amendments that you have before you. Are there any questions about these amendments as modified? All those in favor of the amendments, do you have a roll call sheet? Let's do that.
Vice Chair Klausmeier.
Yeah.
Yes. Senator Kramer.
On the amendments, yes.
Yes. Senator Reedy.
On the amendments, yeah.
Yes. Senator Ellis.
Yes.
Yes. Senator Mounts.
Yes.
Yes. Senator Guile.
Yes.
Yes. Senator Lamb.
Yes.
Yes. Senator Hershey.
Yeah.
Yes. Madam Chair.
I vote aye.
Yes.
Okay, those amendments are adopted with a unanimous vote, and we'll go to Senator Kramer.
Question as a point of order on the issue with regard to striking the provisions with regard to the credit unions. Do we need to do a formal amendment on that, or we?
I think you made it, the amendments you all just adopted, I think would cover all the changes that.
Had that, okay, thank you.
Okay, Senator Kramer, you had something you wanted to present to the committee?
Yes, Madam Chair, if this is the appropriate time, I did submit to the committee probably a couple of weeks ago, an amendment that, and I'm not sure this is the best time to offer it. I could be down a couple of important votes.
Which amendment do you want?
Do you need, it's for it to provide labor peace agreements. The question I have is, okay, as far as get to a perspective on how we're going to handle this going forward, are we going to be completing all amendments and vote the bill today? Or will we be revisiting this tomorrow? What is the intention?
It is
Thank you.
my desire that we get through the amendments and the bill today.
Definitely counting votes. Would it be possible for us, Madam Chair, hold off on this particular amendment for the moment.
Sure, and I would just
Thank you.
mention, one of the reasons, as you all know, this bill has funds and taxes in it, and so we are not the only committee of jurisdiction, so it is desired that we can get through this bill, because as you have already seen by the amendments we've adopted, we have created some would say significant differences with the House, maybe not that significant, but certainly things that they did not adopt when they brought the bill over to us. And so this bill has a few additional steps, and because of the ballot question, we know that we need to get something across to the governor. So
Madam Chair, I believe we've lost a couple of very important members of the committee to executive nominations. And if you need to excuse yourself and go as well, Madam Chair, that would certainly be understood. And the demands of you at executive nominations are probably very important, and your participation there.
I appreciate your thoughtfulness, and I will get to my other responsibilities, but did you have you wanted to hold this amendment that ends in 403-622-1? Do you have another amendment? I think your colleague mentioned that he has amendments as well.
Well, there was
Last to
one
consider.
that I wanted to put out there to see if the committee thought it would be appropriate. I think I had mentioned this previously, that it might be appropriate for the dispensaries to utilize a point of sale system that would require the dispensary, before completing a sale, ensure that documentation indicating that the purchaser is of legal age as a verification. It is commonplace now. But I think that, for those of us who are very concerned about underage sales, and the fact that we could have, and I did not see anything in here. I believe we do, with regard to alcohol, have requirements as to what the age of the individual is that can be selling alcohol, and perhaps committee staff could share with us if there are such age requirements in this, but very concerned about sales to underaged.
Senator, I know you've raised this issue, and I'm just wondering, was your suggestion that we direct the new administration to adopt regulations as it pertains to the point of sale and age requirements? Because I know this came up before, and we actually meant to put that language there.
Well, I know we had
Directing them,
conversation. I
yeah.
just didn't know. I know it didn't.
There's been a lot of paper flowing.
I
a
get
lot
it.
of
That's
papers.
why I'm bringing it up now. I think the idea of ensuring that we utilize technology that is absolutely out there, readily available, and it's not all that costly. That we simply provide that, the dispensaries who are given this license to make, to basically print money, ensure that they are minimizing opportunities for sales to minors.
So are you amenable to language that would direct the administration to put forth regulations that speak to
That
protections
utilize?
Yes, that utilize technology to ensure that blah, 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 because I don't think we want to be too specific.
Can we
because it's a
incorporate in that utilization language, point of sales equipment, and then let them take it from there as to how best they would?
Point of sales verification,
Age verification.
age verification. And maybe not use the word equipment.
Okay,
Fair enough.
that could work.
That's sort of a conceptual amendment. Senator Reedy, you have a question?
I just want to join my colleague in making it clear that we do want verification, ID verification. I'm a big supporter of identification when you're going to do things like vote or get pot. So I think it's a great suggestion by our friend. Yeah.
And Madam Madam Chair, can we add and perhaps council can correct me, is there anything in the legislation with regard to at dispensary sales that a person be of a certain age when selling this legal drug?
I think there's a 21 requirement, but I'll have to double check on that.
In the event there's not, can we put in something similar for the to be adopted by the agency as far as age requirements that would be appropriate for selling a legal drug?
I won't be able to get it. I won't find it that quickly.
But that is.
Yeah.
Yeah, that is.
Okay, if it's not there, then can we include it?
Any objection, any concerns about that discussion? No young and selling this. Yeah, Senator Ellis?
Yeah, could I have a summary of the result from that discussion? Because I heard point of sale in 21 and if I could have it summarized by someone, please.
You want me to do it or you want?
It's up to you. There's technology out there, point of sale, that they can verify your ID immediately. So this will direct the administration to develop point of sale technology for use at dispensaries when they're dispensing cannabis. And it also will part 2 will require that employees at dispensaries who sell cannabis must be at least 21 years of age.
Right. So is that point of sale system now required for purchasing of alcohol?
Not necessarily, not all places use it, no.
But yeah, it's not mandatory everywhere.
That's why I was avoiding the word equipment and
Or-
putting a system for verification of
Yeah.
the age of the purchaser.
Yeah, I'm just kind of leery about that because a lot of people in the state adults don't have those kind of IDs. I mean, it's like, and so if we put an additional requirement on something that's legal, then it seems that for verifications, then require more thought, I really would think. And
Yes, you have to be over 21. You have to prove you're
So
over 21.
basically, if somebody purchases alcohol in the state of Maryland, they have to prove that they're 21. And so this is saying that there has to be a process established by the administration to make sure that we are verifying that the purchasers are of legal age to purchase this newly legalized substance.
right, yeah, and so that system, it might only require a real ID.
check.
A real ID, I mean, for it to go through the system, similar to what you need to go through airports required by the federal government. And, it's, I think it might be a little more technical than just saying, hey, have that system verified. It has to do with the type of ID that system would accept. And so,
Not everybody. Valid drivers.
Right, but those same people have to have some proof of age. in
Yes,
order
you have to have
to
some
purchase
proof of
alcohol,
age, yes.
Right? You can't walk into a liquor store and say, I don't have this type, you still gotta demonstrate your age to purchase alcohol. So I guess I'm not following that.
yeah. And so I'm just curious, what types of ID might be required to purchase alcohol, and what type of ID might be acceptable under the system that we are possibly thinking about putting in cannabis.
Yeah, I think that's why we're asking the administration to develop that. I believe that process probably well, I know it does for alcohol purchases now. So I think that we're just ensuring by putting this provision in that same scrutiny is given to a process to make sure that those that purchase cannabis are of legal age.
Okay.
So I think we're avoiding saying what that would be because we have experts that have worked in this space that also work in partnership with the Alcohol Tobacco Commission. And so those provisions that are used by the Alcohol and Tobacco Commission would certainly be available to the new administration.
Yeah, that reassurance is acceptable. Thank you, Madam Chair.
It is in the bill on page, Sally pointed out, page 55. It requires agents to be at least 21 years old who work in the cannabis and so you don't have to do anything there.
Okay. That piece is done. Senator Reedy.
Do we need to vote that amendment or?
On the point of the.
Yeah, so we don't need to vote on since we found in the bill where
Oh, we're
the
good.
language
Okay.
related to 21 exists. And on the second piece, yes, the piece about the language directing the administration to ensure that there are processes in place to verify the age of the purchaser. So that is the motion.
Now, I'll second it. I have something to offer after this, but I didn't know. what the time
Okay.
was. Yep.
All those in favor of that motion, verifying the age of our purchaser through a point of sale system, raise your hand. That's unanimous. That amendment is adopted. Senator Reedy.
Thank you, Madam Chair. And I do have an amendment to like to discuss with the group. I don't know if we're missing 2 members. I don't know what the votes would be for this or not. So maybe it'll be good for, maybe it won't be. But we've had a lot of discussion and this has been a very collaborative process. We've all worked closely, talking to different groups of people. We've had a lot of testimony and we've worked together to on this bill. But this is, I only had 1.
Well, I've got 4 from you, but is this one you sent today?
Today, yes,
Okay,
today. I'm
all right.
sorry, yeah. Some of the stuff I had sent before has been
Yeah,
incorporated, so we
okay.
took care. We dealt with a couple of issues dealing with hemp, but this is one that is hanging out there. And so the amendment is amendment 973626/1. And just to refresh the body's memory, there in 2018, there was a federal ruling that opened up, basically legalized hemp and hemp products for sale. It was, it included a product called Delta 8 among many other hemp byproduct cannabinoids. And in 2019, it was confirmed by the federal government. Thank you. For the federal government, the Attorney General sent a confirmation to the Department of Agriculture, making it clear that Delta 8, which can be intoxicating, but was considered a hemp byproduct, was made it legal. So we have a whole industry of folks who have really sprung up in Maryland since that time. By my count, there's about, based on what I've seen reported, there's about 60 of these businesses, give or take, that are selling Delta 8 products. They are not the bad actors that we're concerned about with gas stations, just selling who knows what. They're part of the association. They've been asking for regulation for quite a long time at the state level, and we're not able to get any. So my amendment, though, we've decided that the committee's basically decided that we're not going to create a separate license for them, short of the 0.3 or short of what the recreational market will be. So what my amendment is just trying to do here is to give an off ramp for these small businesses. It's basically a 12-month delay for them, to give them an opportunity to either one, wind down their business practice, which was completely legal under federal regulations. Give them 12 months. A lot of them have leases, they have employees. So in some cases, they may be able to pivot to some of the hemp products we are going to allow, but in other cases, they may need to close, or they may decide they want to apply for a license. But if they have to immediately shut down July 1st and then try to spin their business back up applying for a license, I think that's a mistake. So what my amendment would do would simply give them until we start to issue the second round of cannabis licenses. And it would give them until it would give them another year beyond July 1st. And let's see, I think it would be something that we could do to give them some additional help. And I think it's a fairness issue with this industry. I do understand that we're making the policy call that if you were going to sell something that is intoxicating, that you have to go get a recreational marijuana license. And I actually understand, and I think I agree with that, to be honest. Before I was thinking we should try to do something, but I understand the point. But I think if we could give a little bit of ground here to allow these businesses, these small businesses, to just have a little more time, I think that would be good. I also will say there's a lot of folks who are going to apply, a lot of businesses are going to apply to try to get a recreational dispensary license. But it's going to take a while for them, other than the current medical marijuana dispensaries. They'll apply and may be able to get up and running, but there's only about 100 of them in the whole state. You're going to have huge demand. And if we want to avoid people continuing to buy from their friendly neighborhood dealer and have them go buy legitimate, it would be smart to have a farm team here of people who at least have a business running that could apply for the license. Doesn't mean they'll get the license. So I think this is a good idea to just give them 12 months. So that's what my amendment does. And I would move the amendment.
Okay, have a motion and a second for a favorable on the Reedy amendment. Are there any questions? Is there any discussion?
I would like you to repeat it
Senator,
again.
Madam Vice Chair?
I'm sorry.
Nope, go ahead.
I would just like you to repeat it. It's 12 months that you want to give them?
Yeah, 12 months. Just a 12-month. I was about to say the word grandfather, but that is not what we're doing. This is a 12-month delay in them having to shut their business down. Otherwise, they have to shut down July 1st. So this is giving them 12 months to decide what to do and to be able to wind down business practices. And again, this is currently a federally legal substance.
Okay, I'm going to go back to Senator Lamb and then over to Senator Ellis.
Okay, thank you, Madam Chair. I've been giving this a lot of thought because I did hear from a lot of folks after the hearing with this concern. And I tend to agree with the need for, I guess, what I've in my head termed like a runway period for them to be able to ramp off, ramp on, and this gives them that time to be able to switch over to one of the other licenses if they want to be able to continue to sell. Give them a little bit more time to do that. Not perfect, no offense, but, I think it still allows, for example, gas stations to continue to sell until this exemption is closed off after 2 years. But I understand the concern here, willing to kind of support this as a runway period for folks.
Senator Ellis?
Yeah, thank you, Madam Chair. I understand the runway period. I'm also understand that the people who sell Delta 8, Delta 9, able to get regular license and continue to sell those products. Am I misunderstood with that? I mean, did I misunderstand it?
Under his amendment or?
No, under the current dispensaries.
Yeah, if I could clarify, it's a great question. So right now, the way this bill in front of us is written, on July 1, they'd have to shut down. There will not be a single license distributed for dispensaries until January 1st of 2024 in the round of licenses. So any new licenses. I think the medicals, yeah, I'm sorry, you know what? Thank you. The medical can convert right away, but they're the only ones, and there's a limited number of those. So there will be no, and the reason we're doing the 12 months is also they wanted the amendment also before you get to the round where we're going to have equity, where we're going to have the equity licenses. This would get them stopped before that, because you don't want to interfere with they're not. This right after it. I mean, the first round is equity. Sorry, I misspoke. The first round is equity licenses, but they're not competing with them. They wouldn't be able to compete under the second round. So they're not. We're also not polluting the pool for those first round of equity licenses.
Okay, so I understand
I'm not doing
that
a
part.
great job.
So,
I'm doing my best.
so if we give them this, is it 2 year?
1 year.
It's 1 year?
1 year.
Okay, I thought Senator Lamb said 2 years, but it's 1 year. So they would get an advantage over others though with the equity as far as in getting a license to sell cannabis through dispensaries.
Well, they wouldn't
So
be able.
I'm sorry, Senator Reedy, and let me just say, I hear your concern, Senator Ellis. To your question, basically, this would be authorizing them to sell this product during the period that applications are being taken for a round of licenses. Yes,
But an important distinction is they could not apply for a license during that round.
yes. And so does that
If we
answer
adopt
your
this.
question?
Okay, so
Yeah.
they can't apply, so getting that
They'd have to wait,
advantage, okay, so they'll have to wait.
but they could stay in business for 12 more months.
Okay. Okay.
And
okay.
so I'm gonna just make a comment and then I'll go to the vice chair in just a moment. So Senator Reedy, I want to make sure I understand because we've all heard from people for whom this is a challenge, what was passed and, I'm not unsympathetic. I guess a part of my concern, it comes from two places. One is confusion in the market. If there are folks out here selling an intoxicating substance that is not regulated, in it, to me, that might confuse the shopper. Once the legalization happens, they might believe that this is the legal regulated substance and therefore be confused. And then secondly, just looking at the fact that a lot of people that we did hear from were asking to continue to sell the non-intoxicating products, which we did try to take care of at the request of members and stakeholders. And so I guess I would just ask you, kind of also hearing Senator Ellis's point, it almost feels like it's letting people jump to the front of the line without an application process where everyone else who is selling these cannabinoids are doing so after having gone through a vetting process with, the state. And so I'm not sure if your amendment considers those things or if you want to respond.
Sure. I mean, number one, you talked about they're selling these intoxicating products. A lot of these stores are selling products. Some of them are mildly intoxicating, but they're not as intoxicating as a lot of what these dispensaries will be selling, which are going to be pushing much heavier stuff. Now, it is true that some of the products can be, so I'm not trying to gloss over that, but a lot of folks go to these reputable type dealers because they have products that were, again, everybody talks about this being a loophole. The federal government said this was allowed. No, I know, but the federal government says this was allowed. And for 12, we're not letting them get ahead because if you made them shut down July 1, they'd just be gone. So they can't apply for a license in this period. We're not letting them apply for a license ahead of other people. We're just saying that they can stay open until they can apply for licenses in the second round with anybody else. And let's be clear, a lot of these, but a lot of these folks also are people who would have been eligible possibly for the equity round, but they would not under my amendment. They would have to wait. But it would give us, I just think it's a fairness issue. If we're going to stop an industry that was operating, and we know some folks have not been good actors, but a lot of these people, there's an association that they've been trying to, they're trying to do things the right way. I learned a lot through this process as to kind of what happened. And I think it's probably good that we're drawing the line at intoxicating and non-intoxicating, but you could argue that we're drawing that line very, very low as to what's non-intoxicating. And I'm not here to make that argument because that is definitely not my wheelhouse. But I do think to me, it's a fairness issue. It's a fairness issue and it's an opportunity. A lot of these folks have, like I said, they have leases, they have employees, and so we're just giving them a little more time.
Understood. And I just, know that this process, the legislation that passed last session anticipated the vote that took place in the fall. And so let me just go to the vice chair.
Yeah, I just have a question. Now, their doors do not have to close if they don't sell those things, the intoxicating things. They can still stay open and have the creams and tinctures and all of that. Is that correct? So nobody's saying they have to close their doors.
Correct.
Okay,
Yes.
so.
Correct. But there are a lot of products that,
And my other thought is when looking at some of the packaging of the different things, they don't even say where the product is made. They don't say what's in the product. And I just have a real problem with that.
So I would say that again, there's a reputable group that have been trying to stop that from happening. And a lot of these stores, they do label their products properly, but I can't get into adjudicating every situation. I think that there are a lot of folks who are reputable small businesses in this space.
And I understand
And
that.
we're allowing now a monopoly to come in to say that, I just think, again, I mean, this is the policy call, right? I think 12 months is a fair thing.
Good, Madam Vice Chair?
Oh, yes, I'm done.
Okay, so we do have a motion and a second in front of us for a favorable on the amendment offered by Senator Reedy. Yep, should somebody ring the bells? Senator Lamb?
So, does this allow tinctures is there any restriction on tinctures?
We have
Tinctures
that
can't-
in the bill. We
so
have that in the
this
bill
would
as
not
amended.
affect tinctures at all.
No, we put that in the bill. We actually amended that after much consideration. Tinctures is in the bill on
The amendment
page,
you approved allows tinctures up to the, the limit. 4-ounce spot dropper bottles of tinctures. That would be, in the amendments you just voted on, they would be a product to continue under the bill as regulated by the administration.
Mhm. Okay. I mean, I also think it's important to point out that some of these are seemingly less intoxicating than Delta 9, but. Okay,
okay, so we have a motion and a second for a favorable on the Reedy amendments. Any further questions? I think everyone's spoken 3 or 4 times. Okay. All those in favor of these amendments, raise your hand. That's 4.
Gotta have one Lamb Reedy.
Okay, those opposed, raise your hand. That's 5. The amendment fails. Okay. Are there any further amendments to the bill or to Senator Mounts?
Thank you, Chairman. We have an amendment that was submitted, and I believe the committee should have in its possession. It's a pretty much a clerical amendment. It deals with the canopy language, the cutoff date. It's on page 39. There's a cutoff date there of October 1, 2022. There were some growers that had submitted paperwork with the commission that they've been approved, but they hadn't actually received their approval from the commission before that October 1 date. And so the amendment would just simply strike October 1, where it's listed on lines 29 and 30, and replace that with December 31, 2022, which would cover the delay that some experienced in filing the approval paperwork with the commission. So it's just a clerical timing thing.
Okay, Senator Mounts has an amendment to change the date on page 39 from October 1, 2022 to December 31st, 2022. Are there any questions? This is related to existing growers.
No, this is.
Are there any questions? Senator Ellis?
Thank you, Madam Chair. Are there any consequences or unintended consequences to these changes? It seems kind of small, but I'm not sure
If I understand from council, Kathy, can you let us get through this amendment first? If I understand, and I want to make sure I verify this with council, this amendment would basically only apply to those growers that are already operating, and it would still keep them under the caps that we
Yeah.
adopted in the amendments for the new growers. Right, so it just changes the date for existing growers by which their size is determined, their maximum size. Okay. Any additional questions?
This allows existing growers to basically do what they're doing.
So we have in the bill that existing growers. What I just said. Are there any further questions? Okay, yeah, there's a lot of paper flowing. That's why I'm just trying to keep us focused on. Okay, so we have the Mounts Amendment in front of us. Is there a motion?
Move favorable.
You can have a motion and a second for a favorable on the amendment that you have in front of you, ending in 23/1. Are there any further questions? All those in favor of these amendments, raise your hand. Okay, those amendments are adopted by a unanimous vote of 1, 2, 3, 4, 5, 6, 7, 8, 9 members, unanimous. Next amendment. Was that all you had, Senator? Great, thank you.
Okay. David has one.
Which one?
The one I just gave you,
Okay.
not the over the state line one, the other one. But I think it may have been solved in the HB2. They were grandfathered in the 50 micro.
Is this the processor grower?
Yes. And I
Was
can't-
it
I
50
can't find it.
micro? Or it was a lottery?
So
On the bill.
basically, this amendment that we're looking for that the vice chair is referencing, it might have been in the amendments we discussed, or is hers doing? Basically, what we did in the bill is we said that those growers that were licensed in a previous round
Right.
could receive a dispensary license.
Right.
No. it was-
Because, right, the growers, but this one, that's what we did in the
Yeah.
amendments we've already adopted.
Yes.
But the vice chair's amendments do what?
I thought we had copies made. I can run copies, or I can just basically explain. What it does is it requires processor to be awarded a micro grow license if they receive stage 1 approval for a processor license. Basically, this allows stage or these processors who are awarded under HB2 to get a micro grow license. Based on the criteria explained in the bill, what you did is you, instead of just allowing them to be granted a license, you allowed them to be put into the lottery without having to go through the pass-fail. This would just grant them a micro grow license
That's a lot.
without the lottery.
Grandfathered them in.
Yes.
Well, it's not really grandfather.
No, you're not grandfather. You're not great. You're just, yeah, it's not a grandfathering. You're just basically granting these folks. It would be a conflict with what was already done, I guess. So you'd have to pick one or the other, whatever you want to do.
I moved the amendment.
So does everybody know what's in front of you? Basically, in the bill, in the amendments we adopted, we said for those folks that were previously licensed through HB2, we would allow those who had the grower license to get a dispensary license, because the people that were in the first round of licenses that were growers got a dispensary license. Okay, the Senate, we also put in the amendment that those licensees that have processor licenses would basically not have to go through the vetting or qualification to become a social equity licensee, but they could be in that pool and be a part of the lottery to get a micro grow license. The amendment before us would change that provision and say that they would not have to go through the lottery process, that they would just be granted a micro grow license. Those processors that were awarded a process license through the HB2 process. Senator Ellis.
Yeah, thank you, Madam Chair. It sounds like they'll be getting additional advantage. And I know with Senator Reedy, that was my issue with the hemp. And so people already in, for them to get ahead of everyone else with this. I mean, I'm trying to remain consistent with how I think through these amendments. And this would give, I believe, an unfair advantage to those people because they already can get into the lottery. And so in my analysis, it was just would be little unfair. I mean, and so not sure if anyone could assuage my reluctance to give that advantage.
Give a second.
I do not have a second on that motion. So that amendment fails. Are there any further amendments? Senator Lamb.
Thank you, Madam Chair. I have an amendment that I think council should have, and we discussed this quite a bit earlier about exemptions to the Clean Indoor Air Act. This amendment just makes absolutely clear that the on-site consumption establishments must comply with the Clean Indoor Air Act. Just very simple.
Well, no, he basically wants to prohibit smoking at on-site consumption.
Yes.
Do you want me to,
Can I
have it here
ask a
somewhere.
question, though? Senator, would your motion, your amendment, if adopted, would that prevent there from being on-site consumption?
I don't think it would prevent them from allowing.
Would it prevent people from smoking cannabis at an on-site consumption site that we just authorized? Or would it put them, like, for example, for the cigar shops, do we have a prohibition from what do we do with the Clean Air Act for cigar sites?
We have an exemption.
Right, so we're basically, if we adopt your amendment, we're saying no one can smoke cannabis at the on-site consumption site. Is that correct?
Let me see here. I mean, I think yes, this would allow them to still consume edibles and also allow them to consume cannabis on kind of the exterior of the facility. But the amendment would be adding to page 51 after the first paragraph at the bottom. This just applies only to indoor consumption, but it doesn't indoor smoking of cannabis.
At the 50 on-site consumption sites that we just,
Right.
okay,
It would allow them to still consume in other ways that are just not smoking.
right. Maybe. Gotcha. Okay, we have a motion and a second for a favorable on Senator Lamb's amendment that starts with the word consumption, other than consumption by smoking. Any questions? All those in favor of the favorable, raise your hand. Okay, let me do a roll call because I see some half hands.
Senator Lamb's amendment. Vice Chair Klaus Meyer. No. Senator Kramer.
Yes.
Yes. Senator Reedy. Yes. Senator Ellis. Yes. Senator Mouts. No. Senator Guile. No. No. Senator Lamb. Yes. Senator Hershey.
Make sure I read this.
The neighbors, the family next door.
Senator Hershey, yes. Madam Chair.
No.
No.
Okay. Favorable.
5 yes, 4 no, passes.
That amendment passes. So the apartment no, I'm just kidding. All right, are there any further amendments? Okay, we have, Senator Kramer.
Thank you, Madam Chair. I'm gonna, I guess, go back to the one that was first distributed and take a run at it just the same. that amendment, Madam Chair, would simply require what I think is a very important piece to this legislation. And if we're going to be talking equity, and there's a lot of equity language in this bill, I think part of that equity is going to relate to how we treat the workers in this industry, and ensure that at the very least they be given the opportunity to participate within a bargaining unit to represent their interests. And this is going to be an industry that has the opportunity to make lots of money for licensees, but not necessarily for the employees, or what the working conditions might be for the licensees in this business. And this is just a relatively simple amendment in that it just provides that the licensee provide either a labor peace agreement to ensure that the workers have the opportunity to meet and discuss labor representation peacefully and without the risk of losing their jobs or finding that they're demoted in whatever it is they're doing, and or that the licensee have a bargaining agreement with an appropriate representative, and in exchange the licensees get a guarantee that there will be no strikes or work stoppages. And I think that that is important to the licensees, and I think it's the very least we should be doing for the workers in this burgeoning industry that could be potentially very abusive to the workers and the employees at all levels, where we're not going to necessarily know what's happening within the various different levels of the processes, and simply ensure that there is an opportunity for the employees to simply avail themselves to the right, participate within a labor bargaining unit. So that is the amendment, Madam Chair.
Thank you, Senator. Can I ask counsel, I know can you tell me what current posture the bill is in as it pertains to
Okay,
this topic?
so this is the labor peace amendment. The amendment you approved a little while ago included language that's on page 41.
Under the amendment package?
No, in the reprint.
In the reprint.
Yeah, this was language that the House put in there that deals with and this is what you just adopted, so it's there would have to be an either or. On or before July 1, 2024, the division, which will become the administration, shall adopt minimum standards for licensed growers, protect the rights of the growers and employees of concerning grievances, labor disputes, wage rates. And the standard shall at a minimum protect the state's interests by prohibiting labor organizations from engaging in picketing. As a condition of licensure, the licensed growers shall comply with the standards adopted under paragraph 1 and negotiate in good faith with employees, any legitimate labor organization recognized by the division. So this is what was already approved. Senator Kramer's is a far more comprehensive look at what would these agreements involve.
Okay, is there any discussion on Senator Kramer's amendment? Senator Ellis.
Thank you, Madam Chair. This is a difficult decision to make. And it seems like it's a mandatory private sector labor agreement. That's like a one size fits all And it's always difficult to do that prescription. Just, and so I guess I need to be. David, you were saying that something in the bill comes close, but not that.
I didn't say, I'm just
Prescriptive.
saying that it's, that
Or-
you've got this in the bill, which we just went through on the reprint, and you have Senator Kramer's amendment, which is, has a very comprehensive approach to labor peace agreements. So it's one or the other, depending on how you, want to proceed.
One or the other, but the description, the process in the bill comes, would you say, a little close to, you can't make that?
I can't say that. That's, it's a policy call for which approach you would prefer.
Okay. Thank you.
Thank you, Senator. Senator Hershey?
Thank you, Madam Chair. I think I would just add that, you know, we already know how difficult the labor market is right now to try to get people employed. And I think that current amendment puts probably some undue pressure on a lot of these startups, especially the HB2s that are just kind of getting their finances together to put together, you know, their team already to work with them. I think the language that we added from what the House sent over probably covers most of it to your question. I mean, it's not as strong as his language, but I think it's something that the businesses will actually be able to operate under, as opposed to something that I just don't think is viable. So I'd vote against it.
Thank you, Senator. Senator Kramer?
Thank you, Madam Chair. And to revisit the language that council just read, I note that what came over from the House states the division shall adopt minimum standards, emphasis on minimum. And that's for licensed growers to protect the rights of the growers. So I am not so sure that this is nearly comprehensive enough to simply address the notion of why in the world would we not provide the opportunity for, again, these licenses are going to be basically the ability to print money. And if we're going to be providing these licenses to these employers who are going to be generating this kind of revenue, why would we not at the very least, provide this labor peace agreement, which simply provides that the owner of this license cannot interfere with the employees trying to at least decide if they want representation through a labor bargaining unit. And that's all it does. I think what the language we currently have is woefully short with regard to protecting the workers. And the bottom line is these are the people who are going to actually be doing all the work. The folks at the top are just the ones with the license. Everybody below them's the ones that are going to be doing the work that generates the revenue, and there will be lots of it. So we are, with this amendment, just simply as a state saying that we as the Maryland General Assembly feel it's appropriate to adopt a policy to ensure that at the very least, the workers have protection to be able to, if nothing else, discuss whether they want to be part of a bargaining unit without being put at risk of losing their employment. So with that, thank you, Madam Chair.
Thank you, Senator. And I just, sitting here kind of as chair, but also as a senator and a colleague, I do appreciate where your amendments come from. The concern that I have differentiating from the House language is this is a multifaceted bill with a lot of different types of businesses that are proposed in this 100 and, I don't know, we're at how many pages? And so I guess my concern is moving too fast. I think that the House language considers standards to protect the rights and deal with grievances and all of that, but we're going from micro licenses to large growers, and your amendment, it doesn't consider all of the different types of licenses and all the difference of types of employers that we have that will be operating under the bill. So I have concerns about being overly prescriptive on the way into a new industry versus letting the industry get established, having some standards put in place, and then taking these conversations from there. So I now lower my hand and become chair again and call on Senator Ellis.
Yeah, thank you, Madam Chair. You very much articulated what my thoughts were. And, you know, God willing, we all will be back in future years, at least for 3 more sessions. And we can look at this holistically from a standalone bill, I do believe, and to really do these in a more prescriptive manner instead of just wholesome. So thank you.
Nobody, I don't think he has a.
Any further discussion on the Kramer amendments? Hearing no motion, we'll move on to the next amendment.
Well, I would move favorable.
Okay,
Yes, Madam Chair, I would move favorable.
I see a hand. Is that a second? Okay, I have a motion from Senator Kramer, second from Senator Lamb. Are there any questions? All those in favor of the favorable on the Kramer amendments, raise your hand. That's 1, 2, 3. Those opposed, raise your hand. That's 6. The amendments fail. Okay, are there any additional amendments for the committee's consideration? Yes, Senator Kramer.
Yes, I'm just going to go down in flames. But I have to engage in the conversation. I do believe that the bill does not provide appropriate revenues, even remotely appropriate for our local jurisdictions. I think it's important that they have a lot at risk, a lot at stake, a lot in the game, but they don't get they get bupkis in the way of return for what's going to happen at the local level. The bottom line is, colleagues, it's going to be local health departments. It's going to be local law enforcement units. It's going to be local government dealing with what we are passing in this very large comprehensive bill. And I noted that a moment ago with the last amendment, it was, well, we've got lots of time to revisit. We are passing a huge bill right now that we're not kicking the can down the road. And I think we need to ensure that local governments are getting a greater share. So with that, I think, as should be expected and would be very appropriate, that with the nominal 9% sales tax that this bill has, I would ask that we consider allowing the locals to have a up to 3% sales tax on sales. I think the 9% is at the very low end to begin with. And I think this would at least afford our local governments, who are going to be responsible for the greatest expense and cost with regard to dealing with what we're passing here at the state level. And of course, then the state is enjoying the revenues that we allow for this additional potential revenue to the locals. I got, Madam Chair.
Any other comments? So let me just ask council, in the bill that we have before us, did we prohibit locals from applying taxes on top of the 9%? And I just am mindful of the fact that the bill that came over to us and the bill that was introduced came in with a 6%, 6% sales tax. The amendments we adopted took it up to 9%. And we increased the local share by 3.5%, admittedly, not a windfall. But the sponsors of the bill indicated that it was never the intent that this be a cash cow or a windfall for government, that our desire in bringing the bill forward was really to reduce the illicit sales and crimes associated with. And so I can tell you, just from having served on work group after work group on this subject, not just this interim, but starting with the 2019 session, there's been a lot of hesitation on members in the General Assembly of associating heavy tax burden associated with this, because the states that have done that have not seen the outcomes that they had hoped for in terms of the move away from the illicit market. So I would, let me just ask if I'm correct with my understanding of the posture we left this bill in as it pertains to local.
Yes, the posture that, again, you just approved on the large packet of amendments specifically says a political subdivision or special taxing district may not impose a tax on cannabis. That's on page 49 of the reprint. It might be in the amendments too. Be in Amendment 8 somewhere. Yeah, it's on page 25 of the amendment, if you'd prefer to look at it there.
Okay, any other discussion on the concept, Senator Kramer?
Thank you, Madam Chair. I would just offer that, yes, when this was first introduced, probably about 3 years ago, the conversation was entirely about the revenues, and that was the logic, the philosophy, the thought process for quite a while, that this was going to be a huge windfall for the state. We were missing out on all this money, and we should do what all the other states are doing and jump on the big money bandwagon. And I know that somehow that kind of shifted a bit, but I would still say that it is going to be a significant windfall to the state, even with the limited 9% retail sales tax. And I'm just looking to give the locals a little bit of help. I think that even if we had the 9%, an additional 3% for a total of 12% retail sales tax, that is well below what many states are doing in the market. And look, you know, whether the 12% or 9% is going to change the illicit market, I don't know. I suspect it probably would not. And again, as I said, we've seen significantly higher taxes in many states. So just seems to me that the counties are going to be taking up all the work, the effort, and the consequences, but they're not getting anything but pennies for what we're at the state level sending to them. That's all.
No,
Thank you,
I hear-
Madam Chair.
I do hear you, and as you know, I was one who fought to get the local share increased. And one of the things that I'll say is some of the additional pots of money, having talked about the impact, the repair, and forget what the exact words are, the other funds, but those funds are also going to local jurisdictions that have experienced the impact of arrest related to cannabis. And so some of those funding that are in some of the other buckets, as our colleague described earlier, some of those funds will also go to local jurisdictions directly and some indirectly, whether it's public health through the public health fund or those other pots that 35% that we just adopted in amendments. So I do hear you. I think this is going to be an ongoing conversation as well. I know you don't want to hear we're back every year, but we're actually talking about money that we have not yet earned. And so, and we all represent local governments and local communities. So Senator Lamb?
Yeah, thank you, Madam Chair. Could I just ask a clarifying question of the sponsors, the sponsor of the amendment? Is there an amendment that you have that has the precise provisions, or I understand kind of the points that you're making, but I lost track of what, or if you're actually suggesting an amendment.
So it was my understanding we were going to have an amendment presented this afternoon. That amendment did not manifest itself. So I am stepping up to the plate and suggesting that before we finish off the conversation on this legislation, that we take a real hard look at what it is this bill is going to do to our local governments. And it's placing all of the burden, the entirety of what we're about to pass, the responsibilities, it's going to be on the locals. And they are getting literally pennies on the dollar. And I just think that we're being a little bit short-sighted in the way we are passing a law that will significantly increase demands on local governments, but we are not providing them the resources to try and afford themselves the ability to deal with the demands that'll be placed on them.
Okay.
So my thought was, if local is fine with what we're giving them with the peanuts, okay. But if they feel that they need help to ensure they can address all the demands placed on them, that just an up to 3% retail sales tax on the sale of the product, it is not a lot, but it would certainly, I'm sure, be a significant help to the locals.
Okay, thank you.
Okay, any further discussion
I would move favorable.
on what?
On the proposed amendment of 3% sales tax, up to.
Okay, that amendment fails for a lack of a second.
Looks like it.
Are there any further amendments? Okay, we have before us Senate Bill 516 as amended with the packet in front of us and the additional amendments that have been adopted by vote this afternoon. Are there any further questions, amendments, proposals? And I just remind the committee, this bill was jointly assigned, so you all know that budget and tax, so y'all can run across the hall and worry Chair Gazone with whatever. No, I'm just kidding. So we have the bill before us, and I'll entertain a motion.
Second.
Have a motion and a second for a favorable on Senate Bill 516 as amended. Let's do a roll call.
Vice Chair Klaus Meyer.
Yes.
Yes. Senator Kramer.
Yes.
Yes. Senator Reedy.
No.
No. Senator Ellis.
Yeah.
Yes. Senator Mount.
No.
No. Senator Guile.
Yes.
Yes. Senator Lamb.
Yes.
Yes. Senator Hershey.
Yes.
Yes. Madam Chair.
Yes.
Yes.
7-2.
7-2.
Senate Bill 516 as amended passes 7-4 that was 3 against.
No, he said.
7-2. 7-2. That bill passes as amended. Thank you all very much. It's been a lot of work. Thanks to staff, council, everybody who's contributed to the bill, and we'll get this over to budget and tax. Meeting adjourned.